Thank you, Madam Speaker, and through you to the members. Madam Speaker, it may not surprise you that I rise in support of this bill today. The bill is simple and it achieves two objectives. First, it outlines how the auditor may audit our administrative operations in compliance with the 2024 ballot petition law and without running afoul of the Constitution. Second, it provides all of our residents with the ability to request, receive, and review our records while maintaining the legislature's ability to serve our constituents. That's it. This proposal advances the call for more transparency urged by many in the Commonwealth, and each provision of both the audit and the public records proposal contained in this bill have been crafted after hearings held by the Special Joint Committee on Initiative Petitions, on which I was privileged to serve for the past 2 terms. As part of those public hearings, we invited and accepted written and oral testimony from proponents, opponents, independent experts, and the general public, including my colleagues here in the Great and General Court. All of those hearings were recorded and available currently on our public website. We considered all of that testimony, and now, as the ballot petition law specifically contemplates, the legislature is acting. This is nothing new. This bill has been available for review and amendment, and in fact, 6 amendments were offered, presumably before the sponsors of those thought they could not improve the legislation and withdrew them. In this legislation, we are acting in a way that provides the maximum amount of transparency while remaining faithful to the Constitution we all swore to uphold. Our power as legislators to govern emanates from the people. Our exercise of that power, in its very essence, the exercise of the people's power. When we come into this chamber to deliberate, we do so speaking for roughly 50,000 of our neighbors and constituents. When we're delayed, when we're prevented from deliberating and debating, our constituents are delayed and prevented from doing so as well. Our Constitution jealously protects the legislature's ability to freely deliberate and to enact the laws that we all live under. Article 20 entrusts the power of suspending and passing laws exclusively to the legislature, or by authority derived from us specifically. This is how our municipalities govern. Article 21 states the freedom of deliberation, speech, and debate in either house of the legislature is so essential to the rights of the people that it cannot be the foundation of any accusation or prosecution, action or complaint in any court or other place whatsoever. Let's make sure we understand that clearly. The freedom of deliberation, speech, and debate in this legislature is an essential right of the people, not of the legislature or of any one representative, of the people that send us here. Inherent in that freedom of deliberation is the unfettered freedom of expression and direct dialogue between constituents and lawmakers that is necessary for strong lawmaking. This demands candor and confidentiality. It's akin to the relationship between an attorney and a client, or a physician and a patient. And the potential chilling of that right is why the proponents of the public records ballot petition specifically proposed to shield communications from constituents and the deliberative process from being considered a public record. We must hear directly from our constituents without them fearing reprisal, infamy, or embarrassment. As chair of the Joint Committee on the Judiciary, I can tell you that we received testimony from adults and minors who survived human trafficking, domestic violence, sexual abuse, mental abuse, physical abuse, many of whom are still enduring ongoing legal battles or are still hiding from their abusers, who were never caught or prosecuted. We received testimony from LGBTQ individuals who explained how they were forced into sex trafficking because they had to leave their home due to their sexual identity. We received testimony from those who share their history of ongoing substance abuse and how it derailed their lives and led them to make choices they otherwise would not have made. It takes courage to advocate for certain positions, particularly as a member of the public. It takes bravery to step forward and share the hardships that happened to those individuals in an effort to make sure it doesn't happen to others. It's our job to help protect these individuals, to ensure that our process of deliberation is safe, so that the individuals continue to come forward to share their stories with us, and that we have the tools we need to make informed decisions about our laws. That is why the power of deliberation is protected clearly and unequivocally in our Constitution. Some may seek these documents and disagree that they constitute deliberative process or confidential communications. They may call for the full production of these documents. So with respect to the public documents, we are indeed providing the residents an individual right to petition the courts for redress of grievances of an alleged violation of this law. The SJC has previously held that, and I'll quote, "In most but not all cases, relief is deserved, if deserved, can be obtained against the Commonwealth or some other defendant other than the governor or the legislature." Other than the governor or the legislature. That's taken from a case from 1993, citing a litany of cases going back in our history. So in order to provide an individual a right to petition the court for our public records, we create a designated legislative records access officer. As with other public records, a document that's a defined legislative record will become the charge of the legislative access officer, who, as other records officers are in other settings, will be responsible for coordinating the response to that request for access to those legislative records. If a private citizen disagrees with the response or the decision of that officer, that citizen can petition the court to say that the access officer is not following the law. That court can then determine whether the grievance is proper or not. And in creating this avenue, we expressly provide our citizens with a direct right to petition our state's Supreme Judicial Court. You don't have to wait in the Superior Court. You have to wait in the District Court. You go right to the Supreme Judicial Court in the name of transparency. We hear that call for transparency, and so we elevate this dispute directly to the SJC should it occur. Contrast that to what happens when one branch of government seeks to compel another branch to act, seeks to force a co-equal branch to submit to the requests and whims of another branch. That very concept, on its face, is violative of our state constitution. Article 30 of Part 1 of the Constitution states, "In the government of this Commonwealth, the legislative department shall never exercise the powers of the executive and judicial powers, or either of them. The executive shall never exercise the legislative and judicial powers, or either of them. The judicial shall never exercise the legislative and executive powers, or either of them, to the end that it may be a government of laws and not of men." It's been a bedrock principle of our republic since its inception. The SJC has affirmed the importance of the independence of the three branches over and over and over again for those who need a constitutional law lesson. I quote, "Declaratory relief is not available against the governor or the legislature. Mandamus is available neither against the governor nor against the legislature. Judicial unwillingness to order the governor or the legislature to act is founded on separation of powers principles expressed in Article 30 of the Massachusetts Declaration of Rights." So with respect to any grievances from the executive in the person of the Office of the Auditor, in response to legislative documents that we provide, in response to an audit request, we establish a constitutionally sound and appropriate process. If the executive branch says that the legislature is not being forthcoming enough in response to requested information, that opinion goes into the Office of the Auditor's report, which is public for all to read, and in response to which the legislature can state its case directly to the people. Let's put this constitutional dispute that many have turned into a political whipping horse into simple terms for all. An appeal from the executive branch to the judicial branch to compel action from the legislative branch is a threat to the independence of all three branches. Giving unfettered authority to one branch of government is not our system of government. Separation of powers is not an esoteric theory. It's a fundamental tenet of our system of representative democracy. 3 independent branches of government. This idea, this reality, would have been remarkable in its own right to note today, given that we're on the verge of celebrating the 250th anniversary of the Declaration of Independence. But it's now essential not only to note it, but to protect it, as we swear to do every time we take the oath of office. We are in different times. We have a Supreme Court of the United States and a United States Congress that have wholesale abdicated their duties and responsibilities, allowing the executive to declare himself immune from laws while he's in office, to ignore existing laws, to issue executive orders and government actions at his whim. A federal executive that says, and I'll quote, "I don't care what the judges think, another fight every day. I don't care what the judges think." We have an auditor who takes to social media just yesterday to say, and I quote, "I don't recognize our legislature right now. That we're a, quote, house of so-called representatives. That we are acting nefariously today because we didn't check with the office of the auditor before acting on legislation. That we didn't check with the executive before acting here as a legislature." Think of that. A constitutional officer saying they don't recognize an independent branch of government and that the legislature should be checking with the executive before we act here today. Otherwise, the act of legislating is inappropriate. That's where we are. The state Supreme Court, the SJC, opined on this very issue, this unique spin on our form of representative government, in March of this year, when they held that leaving the legislative power in the hands of the legislature ensures that popularly elected representatives, rather than the executive or the judicial branch, determine legislative policy. We in Massachusetts have never and will never tolerate the erosion of the pillars of our government. So after guidance from the state Supreme Court, the SJC, and the Attorney General, and the response of the Office of the Auditor itself to inquiries from both the Attorney General and the SJC, we now propose to clarify in statute the scope of the professional audit in conformity with the ballot petition and with our state constitution so that we can indeed move on and do the business of the people.